Because nobody is infallible, no lawyer, no judge, no human being is infallible. We would like to challenge this position, especially on account of the holding that the matter does not bear on the prejudice against the accused persons, and two, the court's non-finding or no comment on whether the purported service of documents on Mr. Ondieki representing the accused persons alongside Mr. Njiru and I.
Secondly, that the court's non-finding
the court's non-finding that the purported service of documents on Mr. Ondieki was actually effectively done on the alleged date. It shouldn't matter that Mr. Ondieki may have forgotten to respond to that question. It matters that the prosecution
it should matter that Mr. Ondieki
did not respond to that issue. It should matter that the prosecution did not produce evidence of service on that day. Because Mr. Ondieki stated as an officer of the court on the record, said he was served with the statements in the last 36 or thereabouts hours. It cannot possibly be a reasonable finding that is adequate time for the defense or the defendants be able to understand what they are charged with and to prepare a defense for themselves. If the prosecution did not produce the evidence, then the benefit of the doubt belies to the defendants. It cannot be to the prosecution that because they allege that they sent on WhatsApp. What is WhatsApp? I know that the Evidence Act allows for electronic service. I am aware about that. However, there must be evidence that indeed that was done. Assuming the accused persons were unrepresented, what would the court be saying? The court would be saying that what the prosecution says is the truth of the Bible or the Quran or the Gita. It must be the prosecution's duty to prove that we indeed served these documents on Mr. Ondieki or Mr. Ndubi or Mr. Njiru or Mr. Biko on this date. And that evidence should have been produced. The prosecution did not deny the fact that there is a matter in Nairobi Makadara Court related to the same offenses against I think some, if not all, of the accused persons. The state did not refute. It is preposterous to assume that what the prosecution says is the capital truth and what the defense says must be defended by evidence. That is not what the Constitution means for this country. I I would apologize for using strong words, but that is really what it means, that the Constitution means something for the citizen and doesn't mean something for the Republic. The citizen is the one protected by the Constitution and not the Republic or the DPP protected by the Constitution. The Constitution demands that the ODPP owes a duty to the citizen and to the court. But for the reason that Your Honor, with utmost humility, has held that this matter was set up for hearing, I think 5 months ago? Yeah. About 5 or so months ago. Can you not ask yourself, how come the statements were being served 36 hours ago? Even if they were served 1 month ago. If the prosecution had investigated this matter in advance and decided to charge the accused persons, they should have been able to serve the statements immediately upon charge. They were not. That should be held against them, not be held against the accused persons. I apologize, but I am feeling that we are going back to the 80s and 90s of this country. And for that reason, I urge you to allow us 14 days to appeal your decision so that the High Court pronounces itself. It is not a delay. There is nothing, these guys are not going to kill anyone. A criminal case does not end. The murder of Robert Ouko, the file has not been closed. 30 years since he was killed. So we cannot hurry a matter that because of the date having been set 5 or 6 months ago, that it must go on today. What is the hurry? Why the hurry by the prosecution? Unless there is an ulterior motive by the prosecution. I know the court, I know we have, there is that thing that was introduced by the current Chief Justice about delivery something, that people must show that they are delivering results quickly. But that cannot be at the compromise of the right to the citizen. The citizen has a right to be heard fairly. And fairness is not about expediency. Fairness is not about speed. Speed is for aircraft and the ships in the ocean. Speed is not about resolving criminal cases especially. In criminal matters, we do not have small claims courts. In civil matters, we have small claims courts because we know that this matter looks like it is resolvable within this little time. Let us do justice, not to do what the rules or what the ODPP or what someone else thinks. We must allow everybody to have their say and we will have our day both in this court, in the High Court, in the Supreme Court, and in the Court of God. So, Your Honor, I plead with humility, irrespective of my kind of unkind language, that you allow us 14 days to make an appeal or an application for revision of your decision. And there is nothing wrong with it. You are not wrong, by the way. Every magistrate, every judge is not infallible. We all make mistakes, even lawyers. Even these ones here, from the ODPP to Mr. Ondieki and myself, and these ones, we make mistakes. But we are allowed to be reviewed. Kindly give us the time. There is no urgency about this case unless the urgency is to convict. If the urgency is to convict, we can allow Mr. Maina Njenga and the others to say we are guilty, convict us, take us to jail, let's go and rot there. But that is not the purpose of the law. The purpose of the law is to give everybody a chance to have a clean slate of a trial. And that clean slate is to say, all right, this is my decision, but if you want to appeal it, I allow you the time to appeal it. And that is what we are asking for. Give us 14 days, which is what the law says. We file an application, whether for review or revision or appeal to the High Court, and then a decision will be taken, and then we proceed from there. No hard feelings. It's not personal. Thank you.
Yes, Your Honor.
Yes.
The court has spoken.
Yes.
Our country is governed by the rule of law and due process.
Yes.
The court is functus official on that issue. And I say no more.
Your Honor, like you correctly put it on record that I was assist of this instruction from ab initio.
Yes.
On that basis, Your Honor, I would just wish to request the court to just give us some few minutes that we can have a bit of housekeeping between ourselves, the DPP and the court, so that you have the gallery released. Then we can just have a conversation among ourselves.
Repeat your application, Mr. Njiru.
We just have a small session.
Yes.
The defense, the prosecutor, and the court for housekeeping purposes, so that you have the gallery released for about 5 minutes.
You want us to
I believe some of things that are going on record, they could be tidied up if we had a bit of housekeeping.
You want us to go to chambers?
You can go to chambers.
I don't know what my friend is saying, but
Yes.
he's suggesting we might need to go to chambers. He can then explain himself. If my colleagues have no problem with it, I am happy. Rather than clear the courthouse because it is full of members of the public and this is a public hearing, we can both step into your chambers. We hear what he's got to say. If he is disagreeing with my application, he says so, then I can walk away and walk to Kisii.
Mr. Ndubi. What is your other? Just a minute, Mr. Omonga, we are not that. Mr. Biko could be having something to say as well.
Your Honor, I will be restrained to take course and deference from my learned senior colleagues.
Yes.
I will have to take a common position because clearly a learned senior colleague intimates that an appeal and or a review or a revision, and Mr. Ndegwa and Mr. Ondieki do defer to functus under the court has rendered itself. We have clients here who have got their lives stopped because of this case. We do seek your directions, and what Senior Njiru proposes makes a lot of sense, even to share with the prosecution side and to tidy up a few things in terms of the potential statement. So as senior suggests, it would not be too much to ask for instead of coming back and forth about the same position. That would give us a clean slate and to see us go forward in terms of housekeeping, in terms of any documentation and any concerns that we may have, at least so that we don't abort the matter tomorrow or the next day, because we are not the only persons being served. The members of the public are here, they're also being served. So if the court diarizes and states that the days are blocked out, it would only be fair and commensurate that we economically utilize them to the advantage of every party. And in this case, that could be best served when we get into the chambers and have a discussion. I do humbly submit.
Prosecutor?
Your Honor, clearly from the application which has been made before the sentiments of the learned colleagues,
Yes.
it's apparent that the defense is like a sheep without a shepherd. Yeah, there's no leadership, Your Honor.
Yes, Mr.
And,
Mr. Njenga.
That's a very polite way of insulting me.
Mr. Njenga, I give this suggestion. If I be going to make a ruling on the submissions that have been tendered, now I think I buy what Mr. Njiru at the moment suggests, but Mr. Njiru,
Yes, Your Honor.
can't you have your housekeeping between yourself and the prosecution
Yes, we can have a housekeeping
without
without the court. We can. We've granted 5
How many
minutes.
minutes?
5 minutes will suffice, Your Honor.
5 minutes.
Yes, Your Honor.
So that if you don't agree, then Mr. Njenga can make a response, then I make a determination.
We're most of
Then we move on.
5 minutes, Your Honor.
I give you Mr. Ndegwa was generous early in the morning. I want to return the favor. You fast for 5 minutes, I'll give you 10.
Thank you. Thank you very much.